Good morning. I'm Zach Griffin, Senior Managing Attorney at GTX Legal. Before we dive into contract playbooks and what they are and how they're important and can improve your business, just want to zoom out and give you a quick overview on who GTX Legal is and what we help companies do. GTX Legal is a law firm focused solely on helping PE-backed and high-growth companies with their high-volume routine contracts, specifically their customer agreements, vendor agreements, and NDAs. We help them process those agreements at scale and do so in a cost-effective and value-added manner. We really become their contracting engine, we call it. And we help turn legal from a bottleneck into a growth driver. Now, I often get questions about our contract playbooks. We develop contract playbooks for each of our clients, and we have specific playbooks for each contract type that we handle. And contract playbooks for us are an integral part of our process and really help with streamlining the review of these agreements. And so I'm often asked, Zach, what is a contract playbook? Or what do they look like? Or why are they important? Or how can they really help with contract negotiations? So I wanted to take the time to address some of those common questions today and hopefully shed light on what it is we do and why I think contract playbooks are important, not only for us and our clients, but for anybody negotiating contracts on a day-to-day basis. So let's start from the beginning. What is a contract playbook? A contract playbook for us is a document that contemplates all of the specific issues we anticipate seeing in a particular contract type, which is why we have playbooks for each contract type, because the issues that might come up in a customer agreement vary from the issues we might see in an NDA, for example. And so we create a document that tries to address all of the potential issues we're going to see in that document type. And what we will do is we will create a matrix of sorts, which I'll show you in a second what it looks like, where we go row by row, issue by issue, and outline, okay, if we see this issue in a contract, this is going to be our initial position we're going to negotiate for. Here's our fallback if the counterparty pushes back. And here's our best and final, or hey, we need to discuss and escalate this to our client. And so that allows us to consistently negotiate contracts on behalf of our clients. So we build these contract playbooks at the beginning of every client engagement. We really get to know our client's business. We get to understand their level of conservativeness, and how they want to approach various contracts. And we try to calibrate each playbook based on the client's business, the potential risks associated with that business, and their desired approach for negotiating. We have some clients that are very conservative and want to negotiate hard every single issue. We have other clients that aren't as conservative and they just want to focus on the material points that are for their business. And we're happy negotiating all different styles. But again, that kind of gets built into each of the playbooks and how we recommend clients build out those specific positions. So what does a playbook look like? I'll give you a quick idea of what these playbooks look like. Let me share my screen real quick, and I will show you exactly an example of what one of our contract playbooks looks like. So this is a sample contract playbook that we use on a day-to-day basis. And at the beginning, the contract playbook has what we call the workflow section, which just really outlines, okay, we get a document in, this is how it's going to flow through, who's going to review it and how it's going to go from initial request to finish. We also outline if we have to escalate to any particular person, who do we escalate issues to. And we set forth just our general timing requirements. But here is really the meat and potatoes of what we consider the contract playbook. Again, this is like a table in Word. And, the top row sets, again, the issue, preferred position, fallback position, final position or check with client, and any kind of notes. And we always start off every playbook with what we call kind of like the calibration section. This is the approach guidelines that we craft, again, based on all of our conversations with our client, their particular preferences, their business, because a manufacturing business is very different from a software business. And so these are going to kind of change depending on, what it is that we're doing for that client. So as we go down, here's just an example. Okay. In every contract, there's usually going to be a term, or there should be, and a termination section. This is an example vendor agreement playbook. So we're negotiating on behalf of the buyer of goods and services. Our client is the buyer of goods and services. We call the agreement that we're looking at for those goods and services a vendor agreement. So when we're the buyer of goods and services, when we're looking at the term of the agreement, we often recommend our clients have no longer than a 1-year term, unless, our client is requesting otherwise based on, the negotiations that are going on from a business perspective. Because sometimes they might be entering into a multi-year deal to get better pricing, but the default is 1 year unless the contract requester says otherwise. Sometimes there's differences for strategic vendors, but that is kind of set forth. So we set, okay, here our initial position is 1 year, because the contract itself might have a 2-year term or a 3-year term. So we're going to change it on the outset to 1 year unless the client asks otherwise. If the counterparty pushes back on that change, we'll typically confirm with our client to say, hey, was there any special negotiation going on? Why we want it longer than a year? And if the answer is no, we'll usually push back and try to stick with a year. Same with respect to auto renewal. So on the first set, oftentimes, particularly with like software agreements, there's always auto renewal. And that's something that can be problematic when you're the buyer of goods and services, right? Because maybe you're not liking the service as much as you thought, and you don't want it to automatically renew and get caught in a situation where you forgot about the renewal deadline, and then all of a sudden it passed and you automatically agreed to another year of service. So that's something we typically push back on, is deletion of the auto renewal. Oftentimes, particularly with like software companies, they'll push back and say, no, we need to have auto renewal, the consistency of service, et cetera, et cetera. And so we'll check with our client. In this instance, how this playbook's built out in the sample is, if the client could terminate for convenience at any time to avoid an additional spend, we can accept auto renewal. So if it automatically renews, but our client doesn't have to pay the full fee up front, and can terminate with convenience, that might be a situation where, again, we would accept it depending on the facts and circumstances. But again, if that gets pushed back on by the counterparty, then that's something we're going to have to escalate to our client. And so again, we go issue by issue within an agreement. And this is just a sample, but just kind of show you, we go for termination fees. How do we handle those? Do we need transition assistance post-termination? How would we handle that? Well, payment. What's the payment timing? Again, when we're the buyer of goods and services, we're wanting a longer payment period. So if we're seeing, due upon receipt or net 15, we're typically pushing it at a minimum to be net 30. And again, our client will recommend specific positions based on their situation to fill out all of these boxes. So all of these are currently blank, but all of these were to have recommended positions that are filled out for each client. And so you go through and identify every issue that you might see in a particular vendor agreement. This doesn't contain all of them. Most of our vendor agreement playbooks run around 20 pages. That way, when I go to review a vendor agreement that comes across my desk, this playbook should probably address 95% of the issues we're having to see. And so then that gives us a roadmap of sorts of, okay, when I'm negotiating this playbook or this vendor agreement for the first time, I'm going to be living in this column right here, the preferred position column. I'm going to negotiate and mark up for the first time that agreement using this column. And then when I get feedback from the counterparty, I'll use this column and send out another markup. When I get feedback again from the counterparty, this is the column I'll be living in. So it's really going to help me flow through each round of negotiation and understand, okay, these are the positions that my client wants. Because like I said at the beginning, this playbook, we put it together at the very beginning of every engagement with our clients. And so we spent a lot of time, filling this out. We then present it to the client and say, hey, based on our conversations about your business, the different risk profile that you have, how you typically like to approach agreements. We will fill out a full playbook matrix for them. Present it to them, go through each issue by issue, and confirm, hey, is this how you want us to negotiate these agreements for you? But once we do that, that gives us and them clarity on how they want these documents negotiated for them. So no longer do we need to pull them in for every single issue or every round of negotiation because we've already talked about at the outset, hey, this is how this contract should be negotiated. And at the very bottom of every playbook, we put together some sample language. That's where, again, make it easy. Okay, if I need to drop in a restriction on publicity, boom, I've got my client's preferred language that we will then insert into all of their contracts. And so I'm going to stop sharing my screen. That goes into some of the other questions I get. Okay, why are playbooks so important? Okay, we see that we've got this great matrix that outlines all of the issues in a playbook, but why is that important to have? And so I want to touch on some of the key things from my perspective on why having a contract playbook is so important. First off, it's the rules of the road. It's the map, so to speak. And so the analogy I always use is if you're going to travel to a new city, when you're taking a trip with your family, you're going cross country about 1,000 miles to go visit a new city you've never been to. How are you going to get there? And most people are going to pull out their GPS or a map and outline the route that they're going to take to get there. Similar with a contract. If you get a contract in front of you, how are you going to negotiate it from start to close? Could you fumble your way through it? Sure. Just like you could fumble your way across country and maybe land in your destination. It's not going to be the smoothest, and it's not necessarily going to be how you wanted to get there. Same with the contract. We can negotiate them, but having a playbook makes the process so much more efficient because you know exactly, okay, these are the issues that our client cares about. These are the ones that don't really. And for the ones that they care about, this is how they want us to negotiate it and have their ideal solution. And so it really speeds up the negotiation process because we're not having to spend so much time constantly escalating, emailing back and forth, or having a bunch of internal dialogue within the client to figure out, oh, well, what is our position on limitations of liability? We've done all of those kind of internal discussions at the outset. So we don't have to have them when a contract comes across our desk. It's already been discussed. We've already memorialized what the position is that we want to take, and boom, it's just a matter of executing. So it really speeds up the contract negotiation cycle times. And also it provides a level of consistency that I think otherwise companies don't have, right? Like I used to be in-house, so we had a large legal team of about 11 attorneys, and we didn't have a contract playbook. And so the attorney sitting next to me might be negotiating a vendor agreement very different than how I negotiate a vendor agreement. And how do we know that she's taking the same position on limitations of liability that I'm taking on limitations of liability? Like, unless we're discussing it and going back and forth, we're probably taking very different positions because we didn't have a playbook. A playbook, if we had one, would allow us to be consistently negotiating, and you wouldn't have so much variation of contracts based on who was negotiating. That's a big problem that we see with companies when getting initially engaged and look at some of their historical contracts is there's a lot of variance in the positions that were taken, largely in part that we didn't have a playbook. So X person might be negotiating this vendor agreement, somebody else is negotiating this one, and they look very different based on who was negotiating. Having a playbook provides a ton of consistency because, again, we're all following the same rules of the road. Now, for PE-backed companies or companies that are looking to exit one day and have either a sale or an IPO, this consistency is even more important, right? Because eventually, many of these contracts are going to end up on some sort of disclosure schedule. When a company goes to get sold, it says, there's going to be a representation of warranty of, hey, there are no non-compete restrictions in any of this company's customer agreements, except as listed on disclosure schedule 1.1. Well, if we've got a playbook that we've been consistently adhering to, okay, there's going to be very limited contracts that ever need to get onto that disclosure schedule because oftentimes in our playbooks, it says if there's any kind of non-compete or other restrictive covenant, reject, 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 escalate to client if it doesn't get dropped by the counterparty. And so that list is going to be very finite because it's one that had to go through some high levels of escalation to even ever be accepted. But two, it's going to give you comfort in that schedule and making that representation that there are no restricted covenants other than listed on that schedule because you know all of your agreements have been negotiated against this playbook. And so it really helps you with certainty at exit when they're going through that diligence process of knowing, okay, I've got clean contracts. The buyer's not going to be in diligence, unearthing things that are problematic and are going to cause our purchase price to be decreased or have those uncomfortable conversations because we've been consistently negotiating these contracts year over year. So that's a little bit of like why we think contract playbooks are important. There's other things we can discuss, but I don't want to bore you with those. Those are some of the highlights. I think why contract playbooks are so important. The next question we get is how are contract playbooks built? GTX Legal builds them by basically taking a blank matrix like we're talking about and filling it in based on each client's business, the risk profile, and all the information that we gather at the outset. And then we use our GTX's institutional knowledge of having negotiated thousands of these kind of contracts to say, hey, okay, based on your risk profile, this is the recommended position we would take on this issue because we've seen it come up time and time again, and this is the best way to resolve. And so that's how these playbooks get built out. But somebody that doesn't necessarily have our institutional knowledge can still build out their own playbook. The idea is you just list out every single potential issue you might see in a contract. So I recommend you pull up a contract that maybe you worked on last week and go through it row by row and say, okay, what is this issue? Make a row in the playbook for it. What is this next issue in the next paragraph? Make a row for that. And just go through an entire contract and list out all of the single issues that you come across. And then you can start to fill in each column based on, okay, well, how would I negotiate it at the outset, that particular issue? Okay, if I get pushback on that position, how will I negotiate it again? Pull out that next column. And then, man, what is my best and final position on this particular issue? Fill out the third column. So anybody can build it out themselves. You can build out your contract playbook. There's nothing scientific or secret about going through that exercise. The only thing that we really add to the mix is the knowledge of having seen thousands of these contracts. You can really help craft what's filled out in those columns to be most effective. What we think is actually going to move the needle and get these contracts done and not get caught up in some legal minutia sometimes and love back and forth. We can really advise our clients on, hey, does this issue really matter for your particular business or not? And how we've seen it play out in practice time and time again in various negotiations. Really recommend that even if you're not working with us, you still go through that exercise and build it out. I'm not going to lie. It's very, very time intensive the first time that you do it. It's very time intensive for us, even after doing it many, many, many times. But that's okay. That's a value add that we provide is we will do the heavy lifting for you if you engage us to help you with your contracts. We will put it together. But it is something that you can do yourself, but be prepared. It is going to take some time to do. But it's well worth it because again, when you start negotiating those contracts, having that roadmap is such a relief and it's going to really, really help you. All right. And the final question I wanted to address, people often ask is, okay, you get this playbook set, do you continually update it? How do you improve the playbook? And I think that is a great question. We look at our playbooks as a living document. So once we present it to the client, we go through it, we update it based on those conversations. We'll call it an initial final version. Okay. We're going to lock it down and start processing processing contracts against that playbook. But as we continue to negotiate agreements for this client and we bump up in the situations where we need to escalate to the client, we'll continually revise and update that playbook based on those conversations. Because our client might say, I really wanted to take this position on limitations of liability. And now that we can kind of bump it up against the same issue multiple times and we kind of talked about it the same way multiple times, I think I'd like to revive my stance on it. And it's like, yeah, yes, we agree, or let's give it a few more reps. But if regardless, we'll end up eventually revising the playbook to update what it is our client specifically wants going forward. And again, I mentioned in the beginning, this playbook will probably hopefully cover 95% of the issues, but there's that 5 to 10% that's not covered. And so when those come up and looking in a contract review, and we do have to discuss some of those issues with the client, we'll add to the playbook. So that over time, once we've been working with the client for years and years, we've probably seen 98, 99% of the issues that are going to come up, which is very helpful. So it's very much a living, breathing document that we continually update as we work with our clients and to see more and more contracts and work with them more and more within their specific business. So I hope this is all helpful. That's just a tidbit on contract playbooks, why they're important, how we build them, what they look like. If you'd like any additional information, I'm always happy to discuss and show people, more about contract playbooks and help them put them together. So feel free to reach out at info@gtxlegal.com. We'd be happy to set up a time to chat. Look forward to it. Have a great day.